John, I had a question.
On the dose reconstructions, okay, once you guys get it back, and we have some issues with that situation, because if the person doesn't sign the OCUS one, which is voluntary, all right, then the Department of NIOSH and everything, DACAS, they administratively close it and they send the report to you guys. And then you guys administratively close it too whenever you got the dose report to run the probability of causation. The only thing that was not agreed on was that the claimant signed off, which is voluntary.
No, we don't have it signed. If they have signed the OCUS 1, we don't get a final dose reconstruction report. We simply don't.
No, well, according to Pat Kimball, everything there.
They'll forward the case file back to us, but we legally cannot accept that until they've signed it.
We don't get an actual final report.
Even though that's voluntary?
They can sign it or not, but if they don't sign it, they're not going to get a decision.
We don't get a final report unless OCUS 1 releases it to us.
And well, I think
OCUS 1, and that release.
it's also important, and Denise might be able to help a little bit on this. The OCUS, the form that's being signed is basically you're attesting to the fact that you've given all the information in your possession to help us get through the dose reconstruction process. It's not that you're acquiescing to agree with the dose reconstruction. It's just that NIOSH needs to know you don't have anything else in your possession that's going to help them do a more accurate dose. By not signing that form, you're not doing anybody a favor because all you're doing is hampering our ability to make a decision. You can't even contest the dose reconstruction until we release a decision. So that's what the OCUS 1 is. So it's important for you to understand, if you don't sign the OCUS 1, that's not like you're saying, oh, I disagree with the dose reconstruction, I'm not signing the OCUS 1. All the OCUS 1 is basically a certification you don't have something in your possession that you haven't
that's
given
going
us.
to change that dose reconstruction. And actually, by signing that OCUS 1, you're actually going to be able to request a reopening at that point, where if it's administratively closed and the Department of Labor never gets that. And that's exactly right, too. And I see a lot of people that don't want to sign the OCUS 1 because they feel like if they do that, they're agreeing with the dose reconstruction. Basically, it's just that you have no additional information to give to NIOSH that would assist or add to that dose reconstruction. But
going back to that, we do have information that they did not to do it, and then they refuse to honor it.
Yes.
We also have a problem to where we find out that either employment wasn't given to NIOSH on certain areas, or all the cancers were given over there. And they said they can't do anything until the Department of Labor gives it to them.
That's because it needs to come to the Department of Labor.
And then we go back to the Department of Labor and said, how come you didn't do this? Oh, because that is not a cancer. And we said, well, no, it is a cancer. It says right there it's a cancer.
Well, that's
Why
all part.
didn't you do
That's
That's
all,
part of the case process. If we get more information that would
case.
make us have to change that decision, or the information is sent to NIOSH, we send it back to NIOSH. NIOSH can then redo the dose reconstruction.
Okay.
But we need it first.
Right, but the thing is, then whenever we get to the final adjudication branch, because they're still not listening to us, everything, we cannot talk about that. And we say, no, we're not talking about methodology, we're talking about the application. There's some misunderstanding and training, I think, with this type of, this is the application of the method. The methods are written down in the statute. Their guidelines are written down. But what we're talking about is the application. Here, this person worked with an x-ray machine, industry x-ray machine, and it's not put into the record. You see it right there in his work areas. He's got skin phases, cancers that were not given to him. But yet, oh no, we can't reopen it because they followed their site protocol.
But you can't even, Donna, the problem is that you can't even make that argument if you don't sign that OCUS 1.
Right, but she's now moved on to something else.
So, I mean,
So I'm saying,
the
even
objection,
if we do, we're going on,
you go to
the
NIOSH.
next step.
But that's the way it was written. That's the way the law is. We can't address methodology. Now, we do have our health physicists help them determine what is methodology versus what is application. Our health physicists will then help them address that issue. If it needs to go back to NIOSH, we'll send it back to NIOSH. But that's the process that we have. We are also training them in health physics right now. We've got people going out to the district offices to help them understand these distinctions.
Okay, are you going to then start addressing 42 CFR 81 or 42 CFR 82, which shows that we can request a review, and that was a memorandum signed by Peter Terzic with NIOSH back in 2002 that said that NIOSH will independently review this and not Department of Labor's health physicists.
Rachel forgot to remind everybody she's not a lawyer either.
We have a lawyer right here. Will you please at least look into
What precisely is your question? I can talk, lawyers don't talk about hypotheticals, at least this lawyer doesn't. What's your precise question?
My precise question
Yes.
is that the 42 CFR 82
Right,
and 40
which is
CFR
dose reconstruction,
81,
which is probability of
reconstruction.
causation.
okay, right,
NIOSH's rule.
Right, those are
has
NIOSH.
in there that NIOSH can request a review of a dose reconstruction.
Sure.
Department of Labor can request a review of the dose reconstruction, and the claimant can request a review of the dose reconstruction.
In what?
And the review of the dose reconstruction is to be sent back to NIOSH for
Right.
an independent review.
All-
This is in
all
the policy
those-
procedure memorandum signed by Peter Tursik in 2002.
Okay, so what aspect of that do you want me to answer? All reworked dose reconstructions are done at NIOSH.
No, I'm not talking about rework. I'm talking about review.
That's what you're calling a review and what I'm calling a rework is the same thing.
No, sir. In the definition of a rework means that we're having to redo this because we found something else. And that's still done by the same dose reconstruction person that did the original. A review is done by an independent party.
Then that's a question you should ask a NIOSH person, not a DOL person.
No, sir. They can't get it.
You're
back
referring to their law.
That's what I'm saying. Will you please investigate a difference between a rework and a review, and how we can get an independent NIOSH review of these dose
That's
reconstructions?
That's a NIOSH question. I
No,
have
that's
no
a NIOSH
authority
question.
over
Send it there
NIOSH's
for that.
process.
They can't do a review until you guys send it, and you will send it.
You need to ask, you're referring to something very specific in the NIOSH legislation. You need to talk to
No.
NIOSH about that legislation.
This legislation is
move
what
on.
the Department of Labor is required to follow. That's the
We are
issue.
required to follow our law.
Denise, can
Well,
you help that in any way?
I'm really confused. I'm just sitting here
Yeah,
confused, and I think that I kind of know where you're going with that, and I understand the difference between a rework and a review, and I understand what you're saying. I mean, there was like a multitude of issues here. So if we're talking about, in order for a case to get back to NIOSH for a rework, and I know what you're saying review, but for a rework, that is, and we have PERs, we have things sent us from the Department of Labor for a rework.
Or they've got cancer, or they've got employment,
All
or
sorts of
whatever.
things, right.
That's,
Those
those,
are
those are,
reworks.
yeah,
Those
those
are
are
the
factual
reworks.
questions.
Yes.
If you have a factual dispute about the basis of what we call in DOL the NIOSH summary referral document, the NSRD, which is where we put this claimant has this much covered employment from this period, and has medical evidence of these 15 cancers. If you have a factual dispute about the information that we are giving as our findings to NIOSH so they can do a dose reconstruction,
I'm not getting it.
don't call it application of methodology when you're talking to us. Because that's going to get everybody thinking that you're talking about NIOSH's business. The factual findings you're questioning about, that is our business, and just tell us what the problems are. And if we need to send an amended referral document, we do that all the time.
Well, I understand that, but
Yeah.
there's still another
Communication.
second step.
It's a communication error, though, I think, Donna, and I think what's going on is you're talking about sending something back to NIOSH for an independent review because the person that did the dose reconstruction had left something out that had nothing to do with methodology, or is that correct? Like, you're talking about, let's just have a hypothetical there where
It
you're
was in
saying
the
that
site
somebody...
profile, okay, but it wasn't into their everything. And in the site profile, NIOSH's site profile, it has some type of employment there and exposure there, okay? But whenever we get to the hearing, we say, okay, they did not consider this industrial X-ray dose, okay? So this would not be really a rework, it would be a review, because an independent party then has to say that. It's a separate review.
And I know where you're going with that, because you're thinking something was left out of that dose reconstruction that could have possibly changed that POC.
Right.
And I think that what we need to do maybe is talk to Stu or to Brady to figure out exactly where the miscommunication is and what you need to do. Because actually, if that happened prior to that Opus 1 being signed, I mean, when that happened, did you talk to NIOSH and say this was left out? And they probably felt like that was not going to do anything to change that dose reconstruction. Is that what you're
Correct. So
saying?
that's the same dose reconstruction person that did it.
And
Where
you're
if you
wanting
get a
it-
review, you get an independent party
Let me
to
talk
look
to
at it.
NIOSH and see if as something, and then I'm sure if there's something on that end with them that they would be able to talk, I'll be more than happy to do that.
Right, and I did find that memorandum with Peter Tursick and them stipulating that it is a review, not a rework.
Well, I know what you're meaning by that. I do. I get that. I think there was just some communication issues there. So
And without that, we're being denied due process.
right, and I don't think that's anybody doing that purposely. I think there's just some miscommunication. So please email me, and I will actually get a hold of Stu. But I know exactly what you're talking about, because there are times when they look at that and they think, well, that's really not going to make a difference. We're not even going to get into that. We've accounted for that in this section. So you're wanting a review by a different HP than the one that actually did the actual house reconstruction, right?
Correct.
Okay, well, just send me an email and let me talk to Stu or Grady and see what we can do about that. Okay?
Rachel, I just want to say, I know that this had to be a really hard meeting for you to come to, for all of you to come to, for us, because, we all care a lot. But when you are here spending a couple hours with us, which I appreciate so much, you're not just talking to this room full. We all have, 100, 150.
I see it.
We are not alone.
And this is just kind of what we wanted, and I think if we do this more often, the adversarialness will come down.
I would like that.
And we're so happy that
Thank you.
We all would like
But I do, my question is I remember one time you said to me, and it just clicked, even though you'd said it before, you said, quit arguing with the claims examiner. In other words, quit getting so mad at them on the phone. And it just hit me, and I thought, you know what, I may disagree with how they're interpreting the procedure manual. I don't think that you have to have a doctor say, this is characteristic of CBD, when it is obviously obstruction written by a physician on a PFP. I don't agree with that, but I decided I'm going to find a physician who is trained, who is impeccable, has a great reputation, and I'm going to give them what they want. The other thing, SEM. I don't try to fight SEM. I want to find the process to match the job title that matches my worker on the site and the building for 20 years. And I do that. The problem is it goes to a DMC who hasn't been trained well enough to say, he comes back and says, well, the occupational history questionnaire said you wore PPE. I've got somebody, NIOSH, 27 years, researcher at NIOSH. He will attest to the fact that just because a worker says that they have PPE on does not mean that they're protected, but the DMCs, and a few of us have said, DMCs will come back and it doesn't matter what SIM said. You were wearing PPE, you're denied. And that part is bad. SIM, I work with it. I don't even need to add to it or anything.
Yeah, and I think that we do have a learning curve for our CMCs in terms of their new contract, and we have our medical director trying to work with the contractor to get them trained. I think we do need more training with them. That's part of the reason we're looking at these different DMC reports, to make sure that they're as consistent as they can be, that they understand what they're talking about. So I take your point, and we are trying to work on that process.